You ever lay awake at night thinking about things you shouldn't be thinking about? Missed opportunities, bad decisions. That one thing you said at dinner that ruined the whole table? Yeah, that's insomnia. Dr. Sal Monetti, MD, allegedly.
Hi, I'm Dr. Sal Monetti. And for over 20 years, I've helped people sleep. Until the state told me to stop.
Dr. Monetti ain't your average doctor. He didn't learn medicine from textbooks. He learned it from experience. Courtrooms. Back rooms. And one very intense malpractice hearing.
People come to me saying, "Doc, I can't sleep. My mind won't shut off." I tell them, that ain't your mind. That's guilt. That's when I prescribe Night-Night Veto.
Night-Night Veto is the only mob-grade sleep aid engineered to shut down thoughts, memories, and inconvenient self-reflection. One pill? Your problems don't disappear. You just don't care anymore. Patients sleep through family arguments, construction noise, and in one case, a full indictment. That's results. No dreams. No nightmares. Just pure, uninterrupted, federally unapproved rest. Side effects may include loyalty, amnesia, and suddenly agreeing with whoever's talking. If symptoms persist, good, that means it's working. Customer testimonials. Larry Wong, I took one Night-Night Veto. Next thing I know, it's Tuesday. Frank Pecoraro, I slept so good I forgot who I was mad at. Still don't remember. Feels great. Doctors hate him. Lawyers fear him. The FDA won't return his calls. Is Night-Night Veto right for you? If you're asking questions, probably. Sleep like you're in witness protection because you can't stress about tomorrow. If you never fully wake up, Night-Night Veto is not a real medication. Doctor may not be real. Do not take before a sit-down, during a deposition, or while being followed. Side effects include nodding, forgetting, and unconditional loyalty. Ask your doctor. Unless your doctor already knows better.
Muggs, what the fuck you doing in there, you prick?
Yeah, we can hear you.
Okay, Jessica Briscoe.
Your Honor, we'd be requesting an adjournment this time. There's some more.
She's going to need to, let me just stop you. She's going to need to appear in person. We've had a problem with this defendant. We've kicked her out of our courtroom. I think on 2 occasions. She's come back in. She was smoking.
That wasn't me.
Go over there and don't test.
I can go test. I can either pan out or do something to make that money up, but I can, yes, sir.
I'll grant the motion for. Thank you. Folks, my staff has reported that was you, and it appeared as though you were having sex on the screen.
No.
If she understands them and at this time knowingly voluntarily waived them and lay a factual basis to the added count.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Caitlin Quinn.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of method incarceration at $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. In understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty. Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct? Or had one signed on your behalf?
Yep. Yes, Your Honor. Yep.
All right. Any question regarding any of those rights?
No, Your Honor.
You understand you're giving up those rights on that form,
Yes, Your Honor.
particularly the rights contained in paragraph 5. If you look on the podium, you'll see a copy of the advice of rights. Understand you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes.
Amphetamine in your possession?
Yes, I did, Your Honor.
Did you use it?
I did, Your Honor.
And did you know what you were using was methamphetamine?
Yes, I did, Your Honor.
Ma'am, if I accept your plea, I have to advise you that if you commit misconduct as defined by the Michigan court rules, between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not aware of any, Judge.
All right. Then have I complied with the court rule?
And defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be set for February 11, 2026, 9 a.m. That's before me.
And that's here, Judge, correct?
That is correct.
And Your Honor, can I address bond?
Briefly.
Judge, briefly, my client has no prior offenses. The test did come back, the one that she appealed, and it showed the progress report. It said victims report negative for fentanyl. And I think that was one of the issues that the court kept her. And I think she would acknowledge that she did use cocaine after.
No, well, go ahead, counsel.
No, and I think she would acknowledge that she used cocaine after being placed on bond initially when you put her in jail. She's been in jail since January 8th. And she also, Judge, has been diagnosed. She was taken to the hospital while in custody for gallstones. Apparently, she does not have any gallstones, but she has blood in her urine, and the doctors believe that she has kidney stones. So she does need medical attention.
Well, it was interesting. The reason I took a break was to go back and look at the video. And my staff reported it to me, and it did appear that that's what was occurring. So what I am going to do, not on the defendant's motion, I'm going to adjourn this out to next week, the 5th. You'll have to appear in person, ma'am.
Okay.
That way we can assure you're not smoking and not having sex while you're in court. Thank you. Bond will continue.
Understood, Your Honor. Thank you.
Wow.
Yeah. Wow. You should see the video. All right. Thank you. Mute her and get her out of my court.
Assistant Police Commander Davey Lee on behalf of Mr. Shukai Capehart. Shukai Capehart, can you state your name, please?
Christian Shukai Capehart.
Andrew, I was not able to reach Mr. Shukai Capehart until today, so I would be requesting adjournment for that reason. I do have a green sheet, and I would like to address the bond violation.
Yeah, go ahead. Address his bond violation first.
Your Honor, so Mr. Shukai Capehart indicates to me, and this was verified, we talked about, we did not have a valid phone number for him that has now been updated, and we now also have a valid email for Mr. Shukai Capehart. So we're going to be in clear communication from here on out. Regarding the missing tests, he explains to me that he was overwhelmed with the arraignment and wasn't given paperwork, and he didn't realize he needed to contact community corrections. He does tell me that today.
He what?
He tells me he was feeling overwhelmed that his arraignment did not digest what he was being told he needed to do and wasn't given paperwork.
Well, then why didn't he answer his phone when the community corrections tried to call him?
They did not have a valid number, Your Honor, and that has now been corrected.
What do you mean they didn't have a valid number?
They had a number from a phone that indicates to me was stolen. I would ask the court with letting Mr. Shukat Capehart test today. He does indicate to me that he would not be positive for anything except potentially marijuana metabolites from before he was placed on bond.
So he wasn't in contact with his attorneys, didn't go to community corrections, didn't do anything the court asked him to do.
Your Honor, I believe he wasn't attempting to make contact. He indicates to me
Attempting to make contact with whom?
he indicates that he called our office and was not able to reach anyone. He also indicates that he contacted this
80 people work in that office.
My wife also.
and that his wife also attempted to call.
My wife was in contact. And had documentation of it and everything like that. But I had made it apparent to at my arraignment that I did not have that active 646 area code number. And I gave them 2 numbers that they could try to get a hold of, but I guess they only called the 646. And I had been in contact with people, well, my wife was, but I had no release paperwork or nothing. This is new to me. So
He was told it on the record that he needed to go to community corrections.
That is my understanding, Your Honor.
I didn't know that I was going to let.
I'll adjourn this out 1 week to the 5th, 2026, 9 a.m. You got to follow the court's orders, young man, or figure out how you're going to do that. But at this point, his bond's revoked, defendant's remanded.
Thank you.